Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Shabnam Mehlawat from the Faculty of Law, University of Delhi. This is my lecture number 14 and today I will be talking about the Biological Diversity Act 2002 and its various amendments over a period of time till 2022 in India. We already have had a background in my previous lecture about the International Convention on Biological Diversity, which took place on the Earth Summit, and it was a Magna Carta for all biological diversity protection in the world. So, the Indian law is in consonance with the international law, and it provides for the conservation of biological diversity with sustainable use of its components, fair and equitable sharing of benefits which are arising out of the biological resources, the knowledge, and it is inclusive of all matters which are related or which are incidental thereto. India is a country with abundant biological resources with traditional systems and knowledge related to biological resources. The key to these laws originates from the United Nations Convention on Biological Diversity signed at Rio de Janeiro in June 1992, and it came into force in 1993. India was also a signatory and party to the convention. The convention specifically acknowledges the sovereign rights of the states over its territories and the biological resources naturally present in a country. The objectives are similar at the international and the domestic levels of each country, and so is the case with India for the purpose of conservation, sustainable use and fair and equitable sharing, where utilization of genetic resources should be in tune and objectives with the objectives which are to be achieved through the means provided in the convention. What are the Indian laws? Our constitutional law provides the right to protect our rights related to environment, and these rights fall under the harm which might be made under Article 21 right to life, which says that no person can be deprived of his life and personal liberty except for the due process established by the law. So, if a harm comes because of damage to biological resources, it is a violation of a fundamental right, and that right can be specifically enforced. We have our fundamental duties under the directive principles of the state policy, which talk about the duties of the citizens and duty of the state. Right to constitutional remedies fall under Article 32 and 226 in India. Now, coming down to the act is, this act is known as the Biological Diversity Act of 2002, which came into force in 2004. The different dates were assigned for different provisions, but the act as a whole has come into force in the year 2004. It is notified in the Official Gazette of India, where it is declared that the Indian law related to protection and preservation of biological diversity is the current law of 2002. Now, the various definitions which are here are of who are the benefit claimers, which are conservers of biological diversity, their products, creators and holders of knowledge and information with the use of biological resources, innovation, practices associated with such use and application. Biological diversity means the variability among the living organisms from all sources and the ecological complexes of which they are a part, and includes diversity within species or between species and of ecosystems. The biological resources are the plants, animals, microorganisms of parts thereof, their genetic material and byproducts with actual or potential use of value, but does not include human genetic material. So, the biosurvey and bioutilization are survey or collection of species, subspecies, genes, components and extracts of biological resources for any purpose which might be used as a part of the biological usage. The chairperson is the person who is in charge of the National Biodiversity Authority. Then the commercial utilization is very important for biological diversity resources. It means uses of biological resources for commercial utilization, such as making of drugs, industrial enzymes, food flavors, fragrances, cosmetics, emulsifiers, oleoresins, colors, extracts and genes, which are used for improving crops and livestock through genetic intervention. But it does not include the breeding or traditional practices which might be used in agriculture, horticulture, poultry, dairy farming, animal husbandry or beekeeping. Then comes the definition of fair and equitable benefit sharing. It is the same as given under the National Biodiversity Authority under section 21, which we will be covering a little later on. The local bodies under this are the panchayats and the municipalities. The member is a person who is a member of the National Biodiversity Authority or a state biodiversity authority and includes the chairman. The National Biodiversity Authority is established under section 8. The research means study of systematic investigation of any biological resources or technical application that uses biological systems, living organisms or derivatives to modify products or to process any of its uses. The board is that which is created under section 22 of the state and is known as the State Biodiversity Board. Sustainable use means the components of biological diversity are used in such a manner and at a rate that it does not lead to a long-term decline of the biological diversity, maintaining its potential to meet the needs and aspirations of the current and the future generations. The value-added products, it may contain portions or extracts of animals and plants in unrecognizable and physically inseparable forms. Then comes the biodiversity activities and approval of the board. If a person wishes to conduct certain activities which is related to the biodiversity reserves located in a state, he needs to take approval of the requisite authority to conduct his activity. Any person cannot carry any activity on his own without notifying the national authority or the state authority, as the case may be, for the purpose of carrying on the same. So, section 3 talks about that certain persons not to undertake biodiversity related activities without the approval of the National Biodiversity Authority. It says no individual shall undertake any activity without the previous approval. It includes obtaining biological resource occurring in India, knowledge associated for research or commercial utilization for biosurvey and bioutilization. The list of persons who can conduct such activities are a person who is a citizen of India, a citizen who is non-resident but defined in clause 30 of subsection 2 of the Income Tax Act, a body, corporate, association or organization not incorporated or registered in India, incorporated or registered in India under any law in force at that time, which has any non-Indian participation in its share capital or management. So, these are the list of people who can conduct research or carry on activities in India with the approval of the national authority. Section 4 deals with the provisions which relate to research conducted not to be transferred to any persons without the approval of National Biodiversity Authority. That is, the activities which they are carrying on in a place cannot be given to any other person without the approval of the authority or notifying the intention of the same to transfer the same. This provision clarifies that no person without the previous approval of the National Biodiversity Authority transfer the results of any research relating to the biological resources occurring in or obtained from India for monetary consideration or of negativating the previous category of persons who were citizens, non-residents or body corporates. The provision calls for persons who are not Indian citizens or non-residents or a body, corporate or organization which is not registered or incorporated in India or which has any non-Indian participation in its share capital or management. It clarifies the meaning of transfer as not including that work which is utilized for publication of research papers or dissemination of knowledge in any seminar or workshop, if such publication as per the guidelines issued by the central government. The provisions which create a bar for research and sharing results do not apply to collaborative research projects. These are Section 5 clearly outlines that the provisions which apply to Section 3 and 4, they create channelization of work by not allowing research and sharing results without the prior approval of the National Biodiversity Authority, but are not applicable to cases which relate to collaborative research projects. It elucidates further that the previous sections, the person shall not apply to collaborative research, including transfer or exchange of biological resources or information which relates thereto between institutions, including the government sponsored institutions of India and such institutions in other countries, if such collaborative research satisfy the conditions which are specified within the law. All collaborative research projects other than those mentioned under subsection 1, which are based on agreements concluded before the commencement of the Act, or to the extent of provisions of agreement are inconsistent with the provisions of the Act, or any guidelines issued under clause A be void. So, inconsistency to the current law will make that agreement absolutely void. For the purposes of subsection 1, collaborative research projects shall conform to the policy guidelines and have to be approved by the central government. The registration of the IPR rights or the intellectual property rights require the prior approval of the National Biodiversity Authority. It requires that the IPRs are not to be made without the prior approval of the National Biodiversity Authority. That is, no person shall apply for intellectual property rights by whatever name called in or outside India for any invention which is based on research or information on a biological resource obtained from India without obtaining the approval of the national authority before making such an application. The proviso calls for that if a person applies for a patent, the time period of obtaining the patent to be when the permission of the national authority is obtained and the acceptance of the patent, but before the sealing of the patent by the patenting authority. The national authority shall dispose of the application for permission made to it within a period of 90 days from the date of receipt. So, the power of authority includes that this authority, while granting the approval under this section, may impose a benefit sharing fee or a royalty or both, or impose conditions including the sharing of financial benefits arising out of the commercial utilization of such rights. The provision of this section does not apply to making an application for any right under any law relating to protection of plant varieties enacted by the Parliament. Where any right is guaranteed under the law, the concerned authority granting such right shall endorse a copy of such document granting that right to the National Biodiversity Authority. The previous provisions apply to the state biodiversity boards also. So, section 7 talks about the state biodiversity board for obtaining biological resources for certain specific purposes. A person who is a citizen, the same provisions apply. The person should be a citizen of India. He should be or a body corporate, association or organization which is registered in India and obtains a biological resource for commercial utilization purposes, or a bio survey or a bio utilization for commercial utilization shall provide prior intimation to the concerned state biodiversity board. The proviso exempts certain persons from these provisions. These persons are the local people, the communities of the area, including growers and cultivators of biodiversity, the Veds and the Hakims, who have been practicing indigenous medicine. The National Biodiversity Authority to be established. When the Act came into force, they called for the establishment of this authority at the national level to take decisions to look into applications and perform all sorts of functions which are so associated with the biodiversity works. The law, when it is established, it establishes an authority under Section 8. There has to be a specific date which may be notified in the official gazette, and this is to be done by the central government, and it is for the purpose of implementing the provisions of this Act. The National Biodiversity Authority is a body corporate entity. As the name says, it has a perpetual succession, a common seal, and with power to acquire, hold and dispose of property, both movable and immovable, and to contract and shall be sued and sue in the name of that authority. The head office will be located at Chennai, and the National Biodiversity Authority may, with the previous approval of the central government, establish offices in other places in India. So, the constitution of the Biodiversity Authority is, there is to be a chairman who is an eminent person of knowledge, experience in the conservation and sustainable use of biodiversity and in matters related to equitable sharing of benefits, and is to be appointed by the central government. The same case is there with the officials. There are 3 ex-official members to be appointed by the central government. They should be representing the ministry dealing with tribal affairs, 2 representing the ministry dealing with environment and forests and climate change, and the additional Director General of Forest or the Director General of Forests. The 7 ex officio members to be appointed are those from the agriculture and education, biotechnology, ocean development, agriculture and cooperation, Indian system of medicine and homeopathy, science and technology, scientific and industrial research. And the 5 non-official members are to be appointed from the specialists and the scientists who have special knowledge or experience in matters relating to conservation of biological diversity, sustainable use of resources, equitable sharing of benefits arising out of the use of biological resources, the representatives from the industry, conservers, creators and knowledge holders of biological resources. The terms and conditions of these members are that they may be the chairperson and members other than the ex officio members of the authority shall be such as may be prescribed by the central government. Section 10 lays down that the chairperson and the chief executive of the National Biodiversity Authority shall exercise such powers and functions as are prescribed. These persons may also be removed from their office in case of insolvency, of moral turpitude, they have become physically or mentally incapable of acting as members, they have abused their position or rendered to do so in the detriment to the public interest, or have acquired a financial or other interest which is likely to affect prejudicially as a function of his functioning as a member. The meetings of the board, it holds that the authority shall hold regular meetings. They may hold a meeting at such time and place as they may observe under the rules and procedure with regard to the transaction of business of its meeting, including the quorum of its meetings as may be prescribed. The chairperson shall preside at such meetings. If he is unable to attend, then any member of the National Biodiversity Authority chosen by the members present at the meeting shall preside at the meeting. All questions which come before the meeting shall be decided by majority of votes, and the members present and voting, and the event of equality of votes, the chairperson or in his absence, the person presiding shall exercise a second or a casting vote. Every member who is in any way, directly or indirectly or personally concerned or interested in a matter to be decided at the meeting shall disclose the nature of his concern or interest. The person who has a concern or interest shall not attend the meeting, as it is against the principles of natural justice. No act or proceeding shall be invalidated because there is a vacancy or any defect in the constitution, any defect in the appointment of a person, any irregularity in the procedure of the authority not affecting the merits of the case. The committees. Section 13 provides that several committees may be set up to carry out the functions of the National Biodiversity Authority. This authority may constitute a committee to deal with the agro-biodiversity. It further clarifies that agro-biodiversity means the biological diversity of agriculture related to species and their wildlife relatives. It further creates that this authority may constitute such number of committees as it deems fit for the efficient discharge of its duties and performance of its functions. It provides a discretion to the authority that a committee constituted under this section shall co-opt such number of persons who are not the members of the Biodiversity Authority as it may think fit, and the persons so co-opted shall have the right to attend the meetings of the committee and take part in the proceedings, but shall not have the right to vote. So, these are important minute details which need to be followed while setting up an authority or while setting up a committee to carry out the various functions. The persons who are appointed as members of the committee shall be entitled to receive such allowances or fees for attending the meetings of the committee as may be fixed by the central government. The officers and employees, they may be appointed as they are considered necessary for the efficient discharge of its functions. The terms and conditions of such services shall be as may be specified by regulations. Authentication of orders and decisions of the National Biodiversity Authority. All orders and decisions shall be authenticated by the signature of the chairperson or any member authorized by the authority on this behalf, and all other instruments executed by the authority shall be authenticated by the signature of an officer of the authority authorized on this behalf. Delegation of powers. The National Biodiversity Authority may by general or special order in writing delegate to any member, officer of the authority or any person subject to such conditions, if any, as may be specified, such powers and functions of the Act except the power to prefer an appeal under section 50 and the power to make regulations under section 64 as may deem necessary. Expenses of the National Biodiversity Authority to be defrayed out of the Consolidated Fund of India. The salaries, the allowances of the members and the administrative expenses including salaries, allowances and pensions be payable to of the officers and employees shall be defrayed from the Consolidated Fund of India. Section 18 calls for duties of the National Authority to regulate activities referred to in the above sections of section 3, 4 and 6 and to issue guidelines for access to biological resources and for fair and equitable benefit sharing. It may grant approval for undertaking any activity. The authority may advise the central government on certain matters of conservation, sustainable use of its competence and equitable sharing of benefits. It may also advise the state governments in the same manner, and the selection of areas of biodiversity importance are to be notified under section 37 as heritage sites, and measures for management of such sites, perform such other functions as may be necessary. The National Biodiversity Authority may on behalf of the central government take necessary to oppose the grant of intellectual property rights in any country outside India or on any biological resource obtained from India or knowledge associated with such biological resource which is derived from India. So, it has both the power to grant an approval or to oppose the same in respect of intellectual property rights. Approval by application for undertaking certain activities by the authority. Section 19 provides for approval to be given in case a person intends to obtain any biological diversity resource or knowledge associated thereof, or for the commercial utilization of a biosurvey and bio-utilization or transfer the results of any research related to the biological resource occurring in or obtained from India, and shall make an application in a form as may be prescribed. The authority to allow approval for any person who intends to apply for a patent or any other form of IPR rights, whether in India or outside India, shall take an application in such form and manner as is prescribed. The procedure further provides that on receipt of an application, The national authority may make such inquiries as it may deem fit, and if necessary, after consulting an expert committee constituted for this purpose by order, grant approval to any regulations made on this behalf, and subject to terms and conditions as it may deem fit, including the imposition of charges by way of royalty or for reasons to be recorded in writing, also reject the application. So, it has both the power to grant approval or reject that application, provided that no order for rejection can be made without the opportunity of giving the other person a hearing to allow him to show why his activity should be accepted or why his right or patent should be accepted. All formalities are when all formalities are completed by the authority, they shall give a public notice of approval granted by it under this section. The transfer of biological resource or knowledge. There are permissions and procedures related to the transfer of knowledge by the National Biodiversity Authority. It says that no person has been granted approval under section 19 shall transfer any biological resource or knowledge without the prior approval of the National Biodiversity Authority. A person who intends to do the same shall make an application on this behalf in the form and manner as is prescribed. On receipt of the application, it will make inquiries, and if necessary, consult an expert committee constituted for this purpose by order, grant approval, and subject to such terms and conditions as may deem fit, including the imposition of charges by way of royalty or reasons to be recorded in writing, reject the application. But they shall not reject the application without giving the person an opportunity of being heard. Then they shall give a public notice of such approval granted by it under this section. This section 23 provides for the functions of the State Biodiversity Board. Section 23 provides for functions of the State Biodiversity Board, which shall be to aid and advise the government in relation to any guidelines issued by the central government or matters related to conservation of biodiversity, sustainable use, equitable sharing, or any of the like matters for the purpose of utilization of biological resources. It may regulate by granting approvals that or otherwise requests for commercial utilization, bio-survey or bio-utilization of any resource by Indians, and it also may perform any other functions which is necessary to do so. The finance, accounts and audit of the State Biodiversity Board. They shall be granted by way of grants or loans with some such sums of money as the state government may think fit. It lays down certain conditions that constitution of a State Biodiversity Board shall be constituted and be credited by grants and loans. By grants and loans made by the National Biodiversity Authority or by the State Biodiversity Authority, all sums received by the State Biodiversity Board from such sources may be decided upon by the state government. The State Biodiversity Board shall be applied for management and conservation of heritage sites, compensation or rehabilitation of any section of people economically affected by the said notification, conservation and promotion of biological resources, the socio-economic development of areas from where such biological resources or knowledge associated has been accessed subject to any order made under section 24 in consultation with the local bodies, the meeting and the expenses incurred for the purposes authorized by this Act. The audit and the annual reports. For all these activities, the State Biodiversity Board, all audits will be carried out on all activities which are being carried by the board, and they shall prepare an annual report every year with respect to such expenses which have been met out, and the copy of the accounts will be a report which will be prepared. Then this report and the audit report taken together will be placed before each house of the state legislature. So, that is an ancillary function where it says all activities must be audited and all activities must be prepared in the form of a report for the parliament or the state legislature to be notified of all the expenses that have been incurred. The duties of the central and the state governments. The central government shall develop strategies, plans, programs for conservation and sustainable use, and identify and monitor areas which are rich in biological resources, promotion of in situ, which is within, and ex situ, which is outside, of conservation of biological resources, incentives for research, training and public education to increase awareness. While the central government has reasons to believe that any area which is rich in biological diversity, biological resources and their habitats is being threatened by the overuse, abuse or neglect, then they shall issue directions to the concerned states to take immediate measures, and such states shall, with the technical and other assistance that is possible to be provided and needed, will be given by the central government. The central government shall, as far as practicable or as it deems appropriate, integrate the conservation, promotion and sustainable use of biological diversity into relevant sectors or cross-sectoral plans, programs and policies. They shall undertake measures for assessment of the environmental impact of a project which may have adverse effects on biological diversity, with a view to avoid or minimize such effects and appropriately provide for public participation in such assessment. To regulate, manage or control the risks associated with the use and release of living modified organisms resulting from the biotechnology likely to have adverse impact on the conservation and sustainable use. They shall endeavor to respect and protect the knowledge of the local people related to biological diversity, and as recommended by the national authority, such measures may include registration of such knowledge local, state or at national levels, and all other measures protection including sui generis system. So, for the purposes of this section, ex situ conservation means conservation of components of biological diversity outside their natural habitats, and in situ means the conservation of ecosystems and natural habitats and the maintenance and recovery of viable population of species in their natural surroundings, and in the case of domesticated or cultivated species, those surroundings that have developed their distinctive properties. The declarations and notifications of the government. Biodiversity heritage sites may be declared by the government. Without prejudice to any law being in force, the state government from time to time, in consultation with the local bodies, may notify in the official gazette areas of biodiversity importance as biodiversity heritage sites, may frame rules for management and conservation and scheme for compensating or rehabilitating any persons or section of people who are economically affected by such notifications. For the declaration of heritage sites, the process remains the same when the acquiring of land by the government takes place. They take into account the register and the names of the people who are living or who own the lands, and for that purpose they are given compensation for the government which is taking over the lands, and then it needs to work for rehabilitation of those people who have been displaced because of government acquisitions. The power of the central government to notify threatened species. Without prejudice to the provisions of any law, the central government, in consultation with the concerned state government, may from time to time notify any species which are on the verge of extinction or likely to become extinct in the near future as a threatened species, and prohibit or regulate collection of any purpose and take appropriate steps for rehabilitation and preserving those species. For example, the project Tiger. Tiger has been moved several places for its protection purposes, and in certain areas where it feels at ease, and there it is bred and looked after to multiply so that it does not become extinct. The power of the central government to designate repositories. Now, the government may, in consultation with the National Biodiversity Authority, designate institutions as repositories for different categories of biological resources. They shall keep in safe custody the biological matter, including voucher specimens deposited. Any new taxon discovered by any person shall be notified to the repositories or any institution designated for this work. They shall deposit the voucher specimens with such repository of institutions. The power of the government to exempt certain biological resources which are normally traded as commodities. The power of the central government to exempt certain biological resources which are normally traded as commodities, because they do not fall into that rare or the threatened species category. They may allow those resources to be utilized otherwise than those which are threatened. The Biodiversity Management Committee, a constitution of a Biodiversity Management Committee. Every local body shall constitute a biodiversity management committee within its area for the purpose of promoting conservation, sustainable use and documentation of biological diversity, including the preservation of habitats, the natural habitats of the animals and the species, conservation of land races, folk varieties and cultivators, domesticated stocks and breeds of animals, microorganisms and chronically of knowledge related to biological diversity. The cultivar means a variety of plant that has originated and persisted under cultivation or was specifically bred for the purpose of cultivation. Folk variety means a variety of plant that was developed, grown and exchanged informally amongst the farmers. Landrace means the primitive cultivar that was grown by ancient farmers and their successors. The National Biodiversity Authority and the State Biodiversity Boards shall consult the biodiversity management committees while taking any decisions related to the use of biological resources and knowledge which is associated with such resources occurring within the territorial jurisdiction of the Biodiversity Management Committee or the local areas. The Biodiversity Management Committees may levy charges by way of fee collections from any person for accessing or collecting any resource for commercial purposes from the areas falling within its territorial jurisdiction. The Local Biodiversity Fund, there are grants the state government may, after due appropriation made by the state legislature by law in this behalf, pay to the local biodiversity funds by way of grants or loans such sums of money as the state government may think fit for being utilized for the purposes of this act. The constitution of the Local Biodiversity Fund, they shall constitute a fund which is known as the Local Biodiversity Fund in every area, which has been notified by the state government where any institution of self-government is functioning and they are credited thereto. Grants and loans made under section 42, grants and loans made by the National Biodiversity Authority, grants and loans made by the State Biodiversity Authority, fees that are received by the Biodiversity Management Committees, all sums received by the Local Biodiversity Fund from such other sources as may be decided by the state governments. The application, the audit and the annual report. The process followed is the same as before, that where the management and the custody of local biodiversity fund and other purposes there, such fund will be applied in a manner as may be prescribed by the state government. Fund shall be used for conservation and promotion of biodiversity in these areas falling within its jurisdiction and for the benefit of the community in so far as such use is consistent with conservation of biodiversity. There shall be an annual report of the Biodiversity Management Committee. They shall, the persons who are holding the local biodiversity fund shall prepare in such form each financial year a report which at such a time which may be prescribed, with giving a full account of its activities during the previous financial year and submit a copy of the same to the concerned local body. Audits of the accounts of the biodiversity management committees. The accounts of the local biodiversity fund shall be maintained and audited in such a manner and in consultation with the accountant general of the state, and be prescribed, and the person holding the custody of the local biodiversity fund shall furnish to the concerned local body before such date as may be prescribed its audited copy of accounts with the auditor's report. So, annual report and the audit report will be submitted to the district magistrate having jurisdiction over the areas of the local bodies. The miscellaneous provisions. The National Biodiversity Authority is bound by the directions given by the central government from time to time, and they shall discharge their functions and duties under this Act. The National Biodiversity Authority, as far as practicable, be given opportunity to express its views before any direction is given under this subsection. The decision of the central government whether a question is one of policy or not shall be final. Power of the state government to give directions to the State Biodiversity Board is bound to discharge its functions and duties on questions of policy under the Act given in writing from time to time, provided that the State Biodiversity Fund, in as far as it is practicable, be given an opportunity to express its views before any directions is given under this subsection. Decision of the state government is one of policy or not shall be final. Section 50 provides that if a dispute arises between a National Biodiversity Authority and a State Biodiversity Authority, as the case may be, they may prefer an appeal to the central government within such time which may be prescribed. Every appeal should be made in such form as is prescribed. The procedure for disposing of the appeal will be prescribed by the central government, and before disposing of an appeal, they shall be given a reasonable opportunity of being heard. If a dispute arises between the state biodiversity boards and the central government, shall refer the same to the National Biodiversity Authority. While adjudicating any dispute under subsection 4, the National Biodiversity Authority shall be guided by the principles of natural justice and follow such procedure as may be prescribed. So, this relates to the disputes which may arise between two state diversity boards. The settlement of the disputes and power of the authority under the section. The Central Biodiversity Authority, for the purpose of discharging its functions, shall have the same powers as vested in a civil court under the Code of Civil Procedure, which is summoning and enforcing the attendance of a person and examining him on oath, requiring the discovery and production of documents, receiving affidavits for the purpose of evidence, issuing commissions for examination of witnesses or documents, reviewing its decisions, dismissing an application for default or deciding it ex parte. Ex parte means when a party is absent, the court may decide it one-sided. Setting aside any order of dismissal of an application for default or any order which has been passed ex parte, any other matter which may be prescribed. Every proceeding before the National Biodiversity Authority is deemed to be a judicial proceeding within the meaning of the sections 193 and 228, and for the purpose of section 196 of the Indian Penal Code, and the National Biodiversity Authority shall be deemed to be a civil court for all purposes under these provisions. The appeal and execution of the order. The members, officers of the National Biodiversity Authority and the State Biodiversity Board are deemed to be public servants within the meaning of section 21 of the IPC. Appeal may lie any person who is aggrieved by any determination of benefit sharing or order of the National Biodiversity Authority or a State Biodiversity Board may file an appeal to the High Court within 30 days from the date of communication to him of the determination or order of the National Biodiversity Authority or the State Biodiversity Board, as the case may be. The High Court, if it is satisfied the appellant was prevented by sufficient cause from filing in the said period, allow it to be filed further, not exceeding 60 days. So, a discretionary power has been given to the High Court to see if a person is not able to file a case within 30 days, he can further be given time for 60 days more to file his appeal. The execution or determination of an order. Every determination of benefit sharing or order made by the National Biodiversity Authority or a State Biodiversity Board made by the High Court in any appeal against any determination or order of these authorities shall, on a certificate issued by an officer of the National Biodiversity Authority or the State Biodiversity Board or the Registrar of the High Court, be deemed to be a decree of the Civil Court and shall be executable in the same manner as a decree of the court. The explanation further provides that Section 5, the State Biodiversity Board includes a person or a group of persons with whom powers or functions under Section 22 have been delegated under the proviso of the subsection. Certificate relating to such person or group of persons under this section shall be issued by such person or groups of persons as the case may be. Protection of action and penalties in certain cases. Protection of action taken in good faith. No suit, prosecution or legal proceeding shall lie against the central government or the state government or any officer of the central government or the state government or any other member, officer, employee of the National Biodiversity Authority or the State Biodiversity Authority if anything which is done in good faith or intended to be done in good faith, but nevertheless results in a detrimental act will be protected. For example, if a person was trying to save an animal, but it could not do so and the animal died, it is an action which is taken in good faith. Penalties. Whoever contravenes or attempts to contravene or abet the contravention of the provisions of Section 3, 4 or 6 is punishable with a term which may extend to 5 years or with fine or may extend to 10 lakh rupees, and where the damage caused exceeds 10 lakh rupees, such fine as may commensurate with the damage caused or with both. Whoever contravenes or attempts to contravene or attempts the contravention of provisions of Section 7 or any other order under Sections 24 is punished with a term which may is imprisoned for a term which may extend to 3 years or with fine or may extend to 5 lakh rupees or with both. Penalty for contravention of directions or orders of the central government, state government, National Biodiversity Authority or the State Biodiversity Board. If there is contravention of these directions given by any of these said authorities, a person may be punished with a fine which may extend to 1 lakh rupees, or in the case of a second or subsequent offence, the fine may extend to 2 lakh rupees, and in the case of continuous contravention with additional fine which may extend to 2 lakh rupees every day, during which the default continues. Offences by companies which are cognizable and non-bailable. Where offence is committed or a contravention is made by a company, then every person who at the time of offence or contravention committed was in charge of or was responsible for the company or the conduct of its business of the company, he shall be deemed to be guilty of the offence or contravention and shall be liable to be proceeded against and punished accordingly, provided that nothing in this section shall render any person liable to punishment if he proves that the offence or contravention was committed without his knowledge or that he had exercised due diligence to prevent the commission. Notwithstanding anything, where an offence or contravention has been committed by a company and it is proved that it was done with the consent, connivance or is attributable to the neglect of any director, manager, secretary or any other officer of the company, then such persons shall be liable to be proceeded against and punished accordingly. For the purpose of this section, a company means a body corporate and includes a firm or an association of individuals. A director is in relation to a firm means a partner in a firm. These offences are said to be cognizable if they are done with the consent or connivance, they are cognizable and they are non-bailable. Acts to have effects in other acts. The provisions of this act shall, in addition to and not in derogation of the provisions of any other law for the time being in force related to the forests or wildlife protection. Powers of the central government to make rules. Under this act, the absolute power lies with the central government to make additional rules with respect to individual problems in case they arise or in case they are asked to be notified as a form of the policy of the government to frame rules for the purpose of protection of a particular species. There are terms and conditions of the service of chairperson and members under section 9, powers and duties under section 10, procedure under section 12, form and application under section 19, form and manner again under section 19, form of application and manner for transfer of biological resource or knowledge under section 20, form in which time of each financial year is prepared and the date where it is audited together with the auditor's report under section 28, annual statement under section 29, the form in which the appeal is preferred and the procedure for disposing of an appeal and the procedure for adjudication under section 50, additional matter in which the National Biodiversity Authority may exercise the powers of a civil court under section 50, manner of giving notice under section 61, any other manner which may be prescribed in respect of provision which is to be made by the rules. Every rule and regulation made under this Act will be laid before each House of the Parliament while it is in session for a total period of 30 days, which may be comprised in one session, in two sessions or more successive sessions before the expiry of the session, immediately following the session or successive sessions. Both houses agree in making any modification to the rules or regulations, may do so and have the effect of modification form, and they may also if they feel that it is likely to prejudice any form, then they may ask the modification to be made or reject the rule or regulations. The power of the state government to make rules. Similar power exists under similar provisions of the law for the purposes of the state government to frame rules with respect to certain problems. There are functions to be performed under section 23, form in which it is to be made under section 24, form in which at the time of financial report an annual report is prepared under section 33, manner of maintaining and auditing accounts of the State Biodiversity Board under section 34, management and conservation of national heritage sites under section 37, manner of management and custody of the local biodiversity fund which shall be applied in such form under section 44, the annual report during each financial year under section 45, maintaining and auditing the accounts of the local biodiversity fund and the date in which the audited copy of the accounts together with the auditor's report is furnished under section 46, and any other matter which is specified. Every rule or rules and regulations which have been framed will be placed before each house of the state legislature, where it may be accepted or rejected as the rules conforming to that specific problem. The power to make regulations and remove difficulties. The National Biodiversity Authority, with the previous approval of the central government, may by notification in the Gazette make regulations for carrying out the purpose of this Act. If any difficulty arises in the provisions of this Act, the central government may by an order not inconsistent with the provisions of this Act remove that difficulty, and provided no such order shall be made after the expiry of a period of 2 years from the commencement of this Act. Every order shall be laid before each house of the Parliament. The National Board Authority, the chairperson and its members are bound by salary allowances and conditions of service. There are rules which are brought out in the year 2004 under the same Biological Diversity Act of 2002, that the things done or omitted to be done before such supersession, the central government may make the following rules. If they are inconsistent with the existing rules, they will be removed, but if they are consistent with the current rules, then those rules will be framed. The guidelines for collaborative research has been given. The guidelines further talk about the collaborative research projects, guidelines for access to biological resources and knowledge and benefit sharing regulations. An amendment was made in the year 2000 in a proper manner by collection of fees, by collection of forms and then processing those applications. The amendment bill has now been passed in the year 2021 and it was passed by the Lok Sabha in 2023. This bill, it is a compliance requirements for domestic companies, users of the codified traditional knowledge and Ayush practitioners will be exempted from sharing benefits with the local communities. It removes research and biosurvey activities from the purview of benefit sharing requirements, and the benefit sharing will be based on agreements termed between the user and the local management committee represented by the national authority. So, this brings about the reduced role of the local bodies, removal of the prior informed consent, change of the adjudicating bodies as given here. The cases which relate to the Biodiversity Act are the Orissa mining case, the case where mining activities were being carried out and for the purpose of protecting a certain area, the people filed a case and the court ordered that that area will not be used for the same. The case of Sansar Chand versus State of Rajasthan has been previously discussed. The Center for Environmental Law also has been previously discussed, and the case of Banvasi Seva Ashram has been previously discussed. The case of Divya Pharmacy, where the Divya Pharmacy was making medicines and it had a very good effect of those medicines on the people who were taking it. They were asked to share the process and the recipe of those medicines, which Divya Pharmacy refused. This process was then asked under the context of fair and benefit sharing, was asked to be revealed to other companies so that this medicine may be used for commercial purposes and for other people to make use of. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem. But as a sociologist, you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem.